Hello, everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Mr. Scott Seeley with us. He is an intellectual property lawyer and registered patent attorney at Eastgate IP. Thank you so much for joining us, Scott. We are pleased to have you with us today.
Thank you for having me.
Fantastic. It's a pleasure to have you with us. So, Scott, as you know, this is going to be a quick question and answer round, and we would like to ask you some questions, and that we are trying to gather as much as information for our viewers who follow intellectual property or who are intellectual property attorneys. So the first question that we would like to ask you is about yourself. So please tell us about your personal and professional background and your journey in the intellectual property sphere till now.
Yeah, absolutely. Well, so I attended the Central Washington University for my undergrad, where I got a degree in chemistry with a biochemistry specialization. Then I went to the University of Washington School of Law, where I earned my JD. And then I spent several years practicing at Knobbe Martens, Olson & Bear. They're one of the top firms in the nation. And then I founded Eastgate IP shortly thereafter. So personally, I've had a lifelong interest in computers. Even as a kid, I tended to build my own computers. I've done some freelance programming projects in the past, and I've recently earned a certificate in game design. So I've been spending some time trying to apply that learning to my personal projects as well. But overall, I'm basically just very thankful for the broad background that's allowed me to work on a variety of different topics. I've prosecuted patents across a wide array of different technologies, from small molecule compounds to large molecule biologics. I've worked on medical devices, machines, materials, software and electronics. So I'm overall just very thankful to be able to apply my background in this career.
Well, fantastic. So we have somebody with us who is multidimensional, has been doing a lot of things. Thank you so much for giving us that quick intro about yourself, Scott. I would like to ask you a little bit more about Eastgate IP. What exactly you guys have been doing?
Yeah, well, we are a patent prosecution firm primarily, but our intellectual property practice spans most areas of IP. So that includes copyrights, trade secrets, patent prosecution, obviously. We also do a little bit of post-grant proceedings. So I founded this practice with my father, who was, he worked at Perkins Coie for a while as a patent attorney as well. And then he served as chief of IP for Intellectual Ventures for several years, heading up their post-grant practice. So he is able to provide a large amount of insight for the practice that we do before the PTAB.
Okay, fantastic. Moving on, and this would be my first question if I talk about this interview, and we would like to know your thoughts on COVID-19. So we would like to know how legal sector, especially intellectual property, patent law, trademark law, is impacted in the US region due to COVID-19, and what solutions do you foresee from a legal perspective?
Yeah, absolutely. So I think COVID has definitely had some pretty major impacts on the legal industry as a whole. I think the legal industry is notoriously slow to adopt some of the recent technological advancements, but I think as firms have scrambled to try to implement a lot of these work from home procedures, there's been a major increased reliance on some of these new technologies. So I think that we're going to see a lot of increased efficiency as a result of that. I think firms are a lot more common to use a lot of the paperless practices that we're seeing in a lot of other industries today. And those are definitely helping as partners need to work with associates and their staff across different offices as people work from home. But I also think that this pandemic has caused people to reevaluate their budgets and kind of tighten up a lot of the expenditures that companies are used to be willing to put on to patent prosecution. So I think we're going to see tighter budgets. And I think with the combined emphasis on technology and the tighter budgets, I think we're going to see a lot more, some increased efficiency in the workplace for sure. And I think clients are ultimately going to be the beneficiaries of that. I think they'll see some increased access to their documents. They won't need to come in and sign as often. But I also think that the pricing will be more competitive as we move forward out of this pandemic.
That makes a lot of sense, and this is not something that we keep facing every day. So this is for the first time that we had such a thing coming over to us, and we all had to kind of really quickly adapt to new technologies, new strategies, and kind of prepare ourselves to face this pandemic. And I really appreciate your thoughts on that, Scott. Moving ahead,
Yeah.
I would like to ask you about how can a patent attorney add value to a business through patent prosecution?
Sure. So I think it's important as a patent attorney to not just mindlessly be filing applications. I think it's important to understand businesses' goals and how they're going to use that technology. And I think it's important to understand the intersection between law and technology. For example, how patent law distinguishes between different types of technology, what types of technology are easier or more difficult to get through the patent office. So I think that's something that absolutely a patent attorney can help businesses with. So for example, oftentimes businesses will be trying to protect business methods or software methods. And I think it's really up to the patent attorney to recognize that those types of technologies, although they're absolutely eligible for patent protection, they can be more difficult to get through the patent office. So patent attorneys can add value by working with the business to see how this technology is going to be implemented. And perhaps there's a technological feature that's necessary to practice these methods that you can draft an application to emphasize those features. Or perhaps you can frame the problem in a way that will be more persuasive to an examiner, such as trying to show that this innovation actually stems from underlying defects in the technology that exists and that this is a clear improvement over the art. And these are the ways that patent attorneys can add value to the application and not just simply file applications without doing their own due diligence.
Absolutely, very much important to do their due diligence and create all of that at the background before you actually go ahead and file that. Thank you so much for sharing those insights with us. Can you also talk about any interest or recent development in patent law?
Yeah, absolutely. So we actually have a journal article that will be coming out, I believe in the winter edition of the Chicago-Kent Journal of Intellectual Property. So it'll be coming up pretty soon here. But that article will be on recent precedential decisions that have enshrined non-exclusive factors for that the Patent Trial and Appeal Board will consider when deciding whether to institute review of a challenged patent. So very briefly, the Patent Trial Appeal Board, the PTAB, is an administrative body that's tasked with evaluating whether a challenged patent is valid or not valid in view of prior art and some other considerations. And they have a lot of discretion deciding whether to take up a case and institute review or deny review. But recently, there have been some decisions that have been designated as precedential and therefore binding on future panels. And so future panels will need to address these factors when deciding whether to institute or not institute review. And one of these factors is the existence of co-pending litigation. And it's very interesting that there's an open question of whether this was the intent of Congress or well, essentially, several companies have sued. Apple, Google, Intel, and Cisco have sued, and they're asserting that there was that the director overstepped his bound by designating these decisions as precedential, that he overstepped his authority, and that even if it was within his authority to designate these decisions as precedential and bind future panels to consider these factors, that these factors aren't consistent with what Congress intended. So I think it'll be interesting to see how these suits play out because there's not a clear answer. But it is notable that since we've seen some of these decisions designated, we've seen the institution rates drop, which arguably could increase the value of granted patents.
Oh, wow. That's interesting. Since we have been talking about patent prosecution, help us understand how Eastgate IP approach patent prosecutions differently.
Sure. So I think a lot of prosecuting attorneys take prosecution as an adversarial process where they're out to prove the examiner wrong. And I think that's fine and that certainly works. But we found that we've had more success working with the business to try to identify what the most important features of their technology are, and then working with the examiner more as a negotiation to try to identify what the examiner considers to be the allowable aspects of the application, and then using that as a framework that to build a path to allowance to try to make sure that we encompass all of those important features that the business really cares about protecting, but also including all of those features that the examiner wants to see to allow the application. And I think that we've had a lot more success focusing on prosecution more as a negotiation rather than as an adversarial argument to be overcome.
Okay, Yeah, so that's definitely a better way and an advanced way of doing that. Thank you so much for sharing all those great insights with us. Now, a question that is majorly focusing on new legal professionals or new IP professionals, probably students who are still in the law schools. We would like to know, what are those three core values that you truly believe in as an IP professional?
Yeah, absolutely. So I think three core values that we definitely strive to achieve at Eastgate IP would be responsiveness, integrity, and value. So I think as far as responsiveness, a major complaint that a lot of clients have with their attorney is that the attorney just isn't responsive. They don't answer their phone. They don't answer their emails. So obviously we try to answer our phone and answer our emails, but I think it goes a lot deeper than that. I think too many attorneys are satisfied giving non-answers to client questions with answers like "it depends" or "it's complicated." And I think that's fair because a lot of times these questions can be significantly more complicated than the client perhaps appreciates at first blush. But if it's not possible to give a yes or no answer, if the client's answer depends on a weighting of a number of different factors, then at a bare minimum, what we can do is explain to the client what those factors are and how those factors are going to apply to the client's case to empower them to make good decisions. And I think that's a major important part of being responsive that can be neglected.
So you're talking about being responsive with a little bit of transparency there.
Absolutely. It's easy to fall back on and say it's complicated. Any juror will find something differently, but it's much more valuable to a client to understand the factors that are going to go into the analysis rather than just kind of be given this opaque answer of it. Maybe it depends.
Makes sense. Yeah.
That kind of blends well with integrity. I think that there's the old adage that to a hammer, everything looks like a nail. And I think that can be true for patent attorneys. It looks like every problem can be solved by filing a patent application, but oftentimes that's not true. And if we don't think that something's a good path, then we're not going to advocate for it. So for example, if we think that your needs can be met through trade secret protection or by through contracts such as signing a non-disclosure agreement, we'll tell you that and we'll pursue your best interest. And I think that carries along well with value. It's important that patent prosecution is expensive. IP is expensive. Dealing with attorneys can be expensive. So I think it's important that you maximize the client's investment. You need to take the time to understand what the technology the client is interested in, how that technology is going to be used in their business, and then find a way to protect that technology in a way that makes sense for that client. So whether that's filing a quick provisional just in advance of an imminent disclosure, or whether that's filing a broad utility application that you're planning to serve as the foundation for continuation practice for years to come to carve out a niche in a new technological field, those are very different projects, and it serves the attorney well to discuss with the business what their goals are for that technology and make sure that the protection strategy meshes well with those goals.
Oh, fantastic. Thank you so much for sharing those great insights with us. And I think those three core values that you really talked about really can help anyone. I mean, not just in the IP or legal sector, but wherever you are, in whatever trade you are, if you kind of follow those three footprints or those three core values and really adapt them into your daily routine and into your work ethics, that will really take you a way long. Thank you so much for sharing such great insights with us, Scott. With that, we come to the end of this session. I would like to thank you for sharing such great insights with us. We would like to have another chat with you in future on some other trending topics in the intellectual property world. And apart from this, for our viewers, thank you so much for joining us for this session today. Please like and share this video if you like the content, and keep appreciating us to have more coming up from the industry leaders. Thank you for joining us today.